Showing on this edition of Law Weekly, a conversation with a retired customary court president is Honor Miapo Emiaso on the recent conflicting court judgments with regard to the stool of the Emir of Kano. Also showing on the program, highlights from the Justice Reform Summit 2024 of Lagos with the theme Enhancing the Administration of Justice for Economic Growth, Investment, Protection and Security in Lagos. Plus our recap of the top legal stories in the news. Hello and welcome to the program. I'm Shola Shieli. My guest is Worship Emiapo Emiaso, is a retired president of the Area Customary Court in Delta State, where he served for 17 years. He's authored several books, including the best-selling Perceived Corrupt, Memoirs of a Nigerian Judge, which chronicles his time on the lower bench of the Delta State Judiciary. He's currently a senior lecturer with the Faculty of Law, Delta State University. In this interview, I began by asking his views on the conflicting court judgments from Kano and the subsequent summons by the Chief Justice of Nigeria to the heads of the concerned courts.
I read the issues with a sense of embarrassment for the judiciary. I feel for the judges involved because our judicial system is such that a judge will decide a matter based on materials presented before him and not materials that are extraneous to the issues presented before him. Two courts don't sit at the same time, and the parties in these two courts have not necessarily presented the same set of facts. So if you get different results, that is to be expected. Unfortunately, the outside world will see this as two courts of coordinate jurisdiction having conflicting decisions without considering what were the materials that were presented in each of the courts that led to those results. But I am also more embarrassed that these judges are now being summoned to appear, and that decision to summon them is made public. It has a way of affecting the psyche of these judges. The judge must be given free mind to do his work without interference. I think that for these judges to be summoned to appear before the NJC and it's made public is a little bit too much.
The public does not have a right to know that and have confidence in the judiciary. I mean, I think this is what it is geared at.
Yes, I do not say that the public should not know, but not summon a judge and tell the public that I have summoned the judge because of a decision he took. The decision he took that you are uncomfortable with, it's an action that was done by the judge in the course of his judicial functions. He's not supposed to be reprimanded in public.
Well, that's not a reprimand. It's more like for questioning and for investigations. There are no sanctions yet.
For performing my duties as a judicial officer in the course of my usual duties as a judge, we must understand that our system is such that you really cannot run away from the so-called conflicting, except that when I realized that one of those matters went to the Federal High Court on a matter that borders on a chieftaincy issue, I know clearly that the Federal High Court has no jurisdiction for chieftaincy.
So does that not then form a basis for the summoning?
Well, it is not the judge you should summon. It wasn't the judge that filed that matter in that court. So let the NBA call the lawyers who filed those cases and ask them, look, you are lawyers, you ought to know what jurisdiction stands for. You should know that a Federal High Court has no jurisdiction for, why did you go there?
Why did the judge also assume jurisdiction?
Well, fine. I understand that the lawyers who filed that action actually went to court hiding under a fundamental human rights action, but a fundamental human rights action that flows from a chieftaincy matter. So, for a fundamental human rights, the Federal High Court has jurisdiction. Maybe that is why the judge held on to the matter. But to then go on to make interim orders which relate to the parties that are chiefs, maybe the court shouldn't have done that.
So then if summons would give all the parties involved, the judges, and even the lawyers, because the NBA has also asked its ethics committee to look into the actions of the lawyers, we'll give everybody a chance to explain.
What I am saying here is that if the judges in these two suits were wrong, the remedy is an appeal. It's not for you to administratively want to discipline them. You see, the judge, the office of the judge must be protected. Otherwise, the day will come when judges will be afraid to take decisions. You don't intimidate judges. You should let them have a free mind to do their job. And if even we want to call a judge to order administratively, shouldn't do that and tell the public that we have summoned him, we have queried him. No.
But it helps to instill public confidence in the judiciary.
Just a moment. If you do it discreetly and you get to a logical conclusion at which you either find the judge, wanting, or even if you didn't find him wanting, you can then do a statement that these judges were investigated, this was the outcome. But not when you are inviting them and then you are telling the whole world that we have invited them. No, I do not subscribe to, us putting the judges down for these kind of things. If the decision of each of those judges in each of these cases was wrong, let the aggrieved party go on appeal. I'm not saying, we may not administratively call them to order, but then don't call a judge to order or do it that I'm going, and do it in the public. No.
Well, we wait to hear the outcome of the summons that the CJN, sitting as the chairman of the NJC, has issued. I'm sure that will be made public as well.
Of course,
for all we know, the judges might not even be found wanting. So, the jury is still out on.
No, it doesn't feel good for a judge to be summoned before the Judicial Council. It does. I have experienced it. And I know that when I was once summoned to appear before the Judicial Service Commission because of a petition, I knew I had problems controlling my blood pressure. And usually sometimes some of these petitions are so frivolous. We must stop ridiculing our judges. We must stop ridiculing them. It kills the spirit. I've been through it, so when I say it, I know what I'm talking about. It kills the spirit. It kills the interest that you had in the job for doing justice. Because at every time you are now going to be looking at your shoulders and, who could be interested in this matter? If I go this way, will he be offended? It shouldn't be so. It shouldn't be so. A judge should be left to do justice according to law, according to his conscience, and leave the rest to God.
Let's quickly talk about the kind of reforms that you would like to see with the magistracy in Nigeria, because you retired from that bench.
Yes.
And there's been a lot of hue and cry about the way magistrates are treated, whether they are even proper judicial officers. Some of them expect to be elevated to become judges. It never happens. They spend over 20 years, and some other people are brought in from outside and made judges. What kind of reforms would you like to see in the magistracy in Nigeria?
A reform that brings fairness to all judicial officers. A reform that removes any form of discrimination against any judicial officer.
Is there discrimination against magistrates?
Plenty. There is constitutional discrimination against judges of the lower bench. Because when you look at the definition of judicial officer in the Constitution, it does not include judges at the lower bench. But when you look at that term in the Code of Conduct for judicial officers, they are included, which is to say, for purposes of benefits, judges of the lower bench are not recognized as judicial officers, but for purposes of discipline, yes, they are recognized. I mean, that is a clear constitutional discrimination against people on this level of our administration of justice. The discrimination too, even amongst us as lawyers, you know, the NBA, as a body of lawyers, will discriminate against the magistrate in some little petty ways. For instance, you are not allowed to wear your bead as a barrister in the magistrate. You are not allowed to hold MBA offices. In fact, the moment you took the oath to become a judge of the lower bench, the way they treat you is like you cease to be a lawyer. You are no longer a legal practitioner. And I describe them in one of my books that judges of the lower bench are beasts of burden. When it comes to work, they call you. But when it comes to benefit, they don't even remember you.
Away from that interview, we move on now to the Lagos Justice Summit, which was attended by the host governor and which attracted members of the bench and the bar. The program host, the Attorney General of Lagos, in his welcome address, speaks to the essence of the summit.
At the end of this summit, it is expected that stakeholders will recommend lawful ways and means to address delayed justice. It is my desire that civil cases in our courts should not last more than 18 months from date of commencement of the action, and 6 months in case of simple recovery of debt, and 3 months in cases of recovery of arrears of rent and possession of premises.
The Chief Judge of Lagos went down memory lane to the sad incident of the burning of the Lagos High Court Igboshere on Lagos Island during the EndSARS protest and emphasized the need to make the populace understand the legal system.
I've always had to revert back to the sad incidents of the EndSARS protest. And I've always said, whether what was done was right or wrong or evil or sinister, whichever adjective we want to use to qualify it, it is a query on the legal system. Whether we have been doing well or not, whether we have done well enough or not, even if we say that we have done well enough, nothing could have led to such heinous and criminal event as a misunderstanding of the legal system. Therefore, we have a duty to make the citizenry also understand the legal system, particularly its workings, so that with that, they will have more confidence in the system.
The keynote speaker is the former president of the Law Society of Singapore. He spoke on what Nigeria and particularly Lagos can learn from the island country, Singapore. He stressed the importance of simplifying processes and rules by leveraging on technology, strong partnerships, and the need to uphold transparency and accountability in all facets of the justice sector.
Singapore's unique geopolitical features.
The governor of Lagos State, who spoke after him, stressed on the need to think outside the box and do more.
Everybody has spoken well about Lagos, but I'm not satisfied yet. Lagos now needs to take this to an international scale. We cannot sit back and expect that because we're the best in our country, that equates us to being one of the best in the world. Singapore is less than 5 million people, maybe 6 million or 5 million today. and we are 24 million. They don't have two heads. They don't have the kind of the minds and the strength that we have in this state and in this country. We need to be able to think local but act global. The global space is available for us to pick. So, my Lord Justices, it's not about excuses, it's about what are the call that we need to do here today. It's about the bench and the bar. How do we collaborate? How do we ensure that the opportunity that this space has given to us, all of us are using to the best of our capacity? Because I'm not sure that we're driving that capacity well enough.
Governor Sanwo-Olu also used the opportunity of the summit to comment on the suit instituted against the 36 state governors over alleged misconduct in the administration of local government. He described it as a legal anomaly, while noting that local governments in Lagos already enjoy full autonomy.
The Honorable Attorney General of Federation sued all the 36 states because we're not given autonomy to the third tier of government. So the only mistake, which I'm going to tell my young man to take back, some of us are in compliance. So the Honorable Attorney General's office should have done a due diligence to identify which states are not in compliance, so that you don't carry all the 36 states and be able to show example that out of 36, 432 are exempted, is 31 that I'm taking to the Supreme Court. And that's part of the back work that we need to do.
Why do most technocrats in public office live with their reputation smeared? Why do veteran journalists take up political appointments and find it hard to speak truth to power? What's responsible for some even speaking from both sides of the mouth? These and other issues form part of discussions at the 15th anniversary of the 2024 annual lecture of the National Association of Judiciary Correspondents, Lagos branch. It had the theme, Navigating the Delicate Balance between Politics, Law, Media Pressure, and Public Perception, the burden of the Nigerian technocrats in public office. Here are some of the highlights from that event.
As with previous years, our topic for this year's lecture was carefully selected. It aims to interrogate and suggest solutions to some of the many problems facing Nigerian society, particularly in the wake of the 2023 general election, which turned into a tribal and religious contestation instead of what it should have been, recruiting capable leaders.
With these words, the chairman of the National Association of Judiciary Correspondents, NAJUC, set the tone for an interesting conversation from senior lawyers, journalists, and students who are gathered here. The chairman of the event, George Etomi, noted that for democracy to thrive, the country needs a strong and vibrant media. He urged the journalists to continue to live up to the ethics of their profession.
You are to steer society in the right path through your reporting. You will keep government in check. You will keep large institutions in check. You will keep even the ordinary man in check. It is that fine balance that I know that distinguishes a good journalist from an effective journalist. And that's why I said you cannot run away from factually verifying if what you're about to report is going to achieve the aim of steering society in the right path. Because it's so easy to give in to sensationalism at the expense of what is good for society. And in that process, you may begin to lose your relevance.
NAJUC patron, senior advocate of Nigeria, Abiodun Olatunji, harped on patriotism and the need for everyone to play their part.
I observed that as a country, the level of patriotism is super low. You know, we have different issues all over the world in different countries, but you can hardly see an American coming out to run down America as a country. But every here and there on the social media, we see Nigerians running down the country, running down the government. It is we Nigerians that can prop up our country, that can put it on the right path. Foreigners will not come and do it for us.
The guest lecturer, Senior Advocate of Nigeria, Dr. Muiz Banire, examined the challenges and burden faced by a professional in politics and preferred some suggestions for leaving office with one's dignity intact.
I do know from my experience in government also that you find a situation where those legal constraints do exist, but your appointer says, disregard it, don't mind them, go ahead, do it the way you feel it's best to do that. But I always say, if you are a technocrat, please, I will admonish you to refrain from heeding to such suggestion, because at the end of the day, you will bear the burden or the consequence on your own. That time, your godfather, your appointer will not be there for you again. Ensure that your dealings are ethical. Yes, you must be ethical, you must be transparent, you must be accountable. Every action that you take, every omission, you must benchmark it against transparency and accountability, so that anytime they wake you up, you can say, oh, no problem, let's go.
Other discussants also contributed to the topics at hand.
The administration of criminal justice law in Lagos State has banned the public display of suspects. But you see turn on our televisions and you see journalists, judicial correspondents cover where police, EFCC, or whoever it is, display innocent Nigerians who are presumed to be innocent until otherwise proven guilty. And again, the request from the bar is that when the media houses are invited to come and cover such events, you decline and you let them know that the law forbids such things. What happens when you have gone ahead to splash a man's face all over the internet as a suspect, and at the end of the day, the court finds him innocent? Who would pay for the damage that man would have gone through for the entirety of his life?
I disagree with you entirely on the issue of parading criminals. If Vance was not paraded, you will not know him. He was living in the highbrow area, Magodo, kidnapping and being rich. So criminals, if he's free today, the same media will show him on TV that he had been freed by the court and we will hear the news. There's nothing wrong in parading criminals. That's the point I'm making about laws. Laws are made to protect criminals and we will not be part of it. So the media is doing well. I'm only challenging them to do more. Expose corruption. If they sue you, some of us will stand to defend you free of charge. That's what Ghana for me was doing.
I believe, with all due respect to the president, he has not shown the pedigree of what we used to know him for. When the president was the leader of the opposition, every day in Nigeria, all we had was true federalism, resource control, and indeed, sovereign national conference. We cannot allow the president to sleep in Aso Rock and be deemed by the luxury of office. He should show the path to true federalism. That's what we knew President Tinubu for, agitating for true federalism. He can't get there and go to sleep. So I'm challenging all our colleagues in the media that we fight the battle of our people for freedom, for a life of comfort, because there are resources in Nigeria. And if it's properly harnessed, there's no need for anybody to suffer.
Award and plaques were also handed out to deserving personalities at the event.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Chief Justice of Nigeria and Chairman National Judicial Council, Justice Olukayode Ariola, has summoned the Chief Judge of the Federal High Court, Justice John Soho, and the Chief Judge of Kano State High Court, Justice DJ Aboki, for an emergency meeting in his chambers over the conflicting judgments emanating from the two courts with respect to the stool of the Emir of Kano. There are strong indications that the National Judicial Council will also conduct an emergency meeting in the next few days where the particular judges concerned are likely to be invited and subjected to serious investigations. In Abuja, a Federal Capital Territory High Court has commenced the trial of the former Minister of Aviation, Mr. Hadi Sirika, as the prosecution counsel calls its first witness, a retired director of procurement in the Ministry of Aviation. Sirika, his brother Ahmed Abubakar Sirika, and two companies, Enginos Nigeria Limited and Samaha Integrated Investment Limited, are standing trial of an alleged 5.8 billion naira fraud. Still in Abuja, the Federal High Court has adjourned to June the 13th to hear the suit filed by the All Progressives Congress North Central Forum seeking to remove Abdullahi Ganduje as chairman for allegedly holding the position unlawfully. The trial judge, Justice Inyangekwo, adjourned the matter on grounds that processes have not been regularized in the matter. The court therefore urged the lawyers in the suit to ensure that all processes and responses be exchanged before the next adjourned date. In Lagos, a federal high court has again ordered the interim forfeiture of the sum of $1.4 million linked to the former governor of the Central Bank of Nigeria, Godwin Emefiele. Justice Ayokunle Faji ordered the forfeiture of the money to the federal government of Nigeria. The judge also ordered the EFCC to publish the interim forfeiture order in a national newspaper for anyone interested in the money sought to be forfeited to appear before the court and show cause within 14 days, while the final order of forfeiture of the said sum should not be made. Justice Faji then adjourned to June the 25th for hearing of the final forfeiture of the money. And we round off in Rivers State, where a high court sitting in Port Harcourt has issued an order of interlocutory injunction restraining the 27-member Martin Ameule-led House of Assembly from parading themselves as lawmakers. The order was issued by Justice Charles Wali, who adjourned further proceedings to July the 1st. The suit, which had Victor Kojombo and the two other lawmakers loyal to Governor Similaye Fubara as plaintiffs, had Martin Ameule and 24 other members of the Assembly who had defected the APC listed as defendants. Governor Fubara, the Attorney General of the state, and the Chief Judge of the state were also listed as defendants.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Sheli. Thank you for watching, and see you next week.